Two high-profile murder trials in Canada are now putting Indigenous issues under the spotlight. In the Battleford courthouse, Gerald Stanley is on trial for second-degree murder in the death of Colton Boushie. In 2016, Boushie was shot and killed on Stanley's farm near Biggar, Saskatchewan. The trial has put the province on edge, and no visibly Indigenous people were chosen to sit on the jury. In Manitoba, Raymond Cormier is on trial for the death of 15-year-old Tina Fontaine. When her body was recovered from the Red River, it ignited calls across this country for an inquiry into Canada's missing and murdered Indigenous women and girls. Joining us now is Katherine Hensel. She's a Secwepemc lawyer focusing on First Nations issues. Katherine, thank you so much for being here.
Good morning.
Let's talk about the first trial that we were talking about, the Gerald Stanley trial. He's the man charged in the Colton Boushie murder. Is Canada's racial pass on trial in this instance?
In some ways. Yeah. And certainly the perception is reasonable that it is. What you had was a young guy doing what young guys do, and what the jury's going to have to decide is whether Mr. Stanley's actions were reasonable. And Mr. Stanley's a non-Indigenous person living in a rural location. It really does highlight the tensions. And we're seeing it play out throughout the trial process as well already.
We're seeing it play out through the trial, but also in the broader community as well.
Yes. We, Indigenous people in Canada, we know that we are at risk, heightened risk of violence from all different sources, from police in our own communities and from non-Indigenous people. And we feel this fear for our children when they go out. So when they go out into the world as young people, and it's a real fear, and we're looking at this young man who's tragically was killed, and we feel it's a very visceral. We already know what the risks are, but and his family's experienced the tragic results of that.
We talked a little bit before the show about something that made me do a double take when we were doing the research for this. That in the trial, all Indigenous jurors were blocked. Visibly Indigenous jurors were blocked from being part of the jury. Now, explain the legal reasons behind that, and then I don't know why I have I don't know, an inborn problem with this, but there's a justification for it.
Yeah. I don't know if there is actually substantively a justification, but it's legal.
It's legal.
And it is legitimate.
Yes. Okay.
For both the Crown and defense get to challenge jurors, and they don't have to give a reason.
Right.
So Professor Kent Roach, a criminal law professor, wrote in the Globe and Mail yesterday that this is a stone-cold invitation to import the kind of racial bias that really calls into question the fairness of the system, whether it's actually going to be fair and whether it's going to be perceived to be fair by Indigenous people in Canada and by non-Indigenous Canadians as well.
Do you think something like this could live on after the trial? Are we going to be looking into this tradition and saying, you know what, we might want to tweak this in the future?
Yeah, it's been examined on a number of occasions. Public inquiries, the Supreme Court of Canada addressed it in Cacopolis. It's been raised, and nothing's been done to deal with jury representation, and particularly there's barely ever any Indigenous people on juries, and it really does affect the perception of Indigenous people about whether the system is there to fairly judge with respect to our interests.
Let's move on to the Tina Fontaine case, because as we said off the top, it reignited interest in the inquiry into murdered and missing Aboriginal women and girls. How central is the outcome of this trial to that inquiry?
I think the inquiry has such a broad range of cases and issues. This is but one of literally thousands and thousands of cases. It's a loss that was in the forefront of public attention, but unfortunately, it's not an extraordinary case. What's extraordinary about it is the amount of attention and the ability of non-Indigenous Canadians to really understand the nature of the loss and the circumstances around it. So it will be important to see how the fairness of that trial and the outcome, certainly, to see, is the justice system there to protect our children as well?
Well, one of the knocks on the inquiry is that it didn't have the ability to go back and open old cases. This is a case that's currently living in front of the courts. So is it being upheld as sort of, you know, perhaps the one chance to sort of for these two things to live simultaneously, the inquiry and a case simultaneously?
Yes, and the inquiry can consider what happens at that criminal trial. They can't, it's beyond the resources and the capacity of that inquiry to go into all these cases, but there's no doubt that the evidence before that trial, the narrative, the story, the factors, that the inquiry can take that information and hopefully use it to develop recommendations to prevent these kind of deaths, which are, again, not extraordinary.
Well, Katherine, thank you for walking us through the nuances of these cases. We really appreciate it.
Thank you.
Hope to see you again soon.